Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why Attorney-CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of ElderTalk. This week we're going to return, as we from time to time do, to talking about the subject of planning for the very end of your life, things that you may not know that you should know, things you may have heard in the past and didn't fully understand, things you may have completely wrong. In any case, this is a topic that we know is relevant to people as we age more perhaps than when we're young. So I think it's an obligation, particularly of a show that's called Elder Talk with TuckerAllen. It's incumbent upon us to have an attorney from TuckerAllen to talk to us about this and to discuss some of these topics. I think you'll find this very interesting. I think you'll find it very relevant to your needs and hopefully very helpful. Well, Jill, describe our regular and popular guest.
We have Teresa Yao back with us from TuckerAllen. Teresa, thank you so much again for joining us
Thanks
today.
for having me.
And we're talking about mistakes you can make with estate planning and things we really want to avoid. And probably the biggest one is dying intestate. And that means, of course, dying without a will.
It's probably the most common. I'm thinking.
It's dishearteningly common, I would say.
Because people put it off. They don't want to think about it, and they think, oh, I'll do it another day.
I'm not going to die soon.
Right.
Mm-hmm.
So, and it's funny we're having this conversation at a time when coronavirus has just loomed
Yes.
over everybody's lives. So probably I'd like to think, and I think that TuckerAllen has seen this. I want you to answer this question, Teresa. Have you seen an increase in the interest in estate planning during the last 3 to 4 months?
Yes. So when clients come in, I normally ask, oh, what brings you in today? And more often than not right now, people are saying, you know what, I've been putting it off long enough. And they mentioned COVID and how that really was just kind of that catalyst for them to finally start this process.
Good motivation to do so.
Yeah, exactly.
Yeah, well, and there was a time, when clients it wasn't uncommon for a client to come in, and then if they refer to the big C or something, we all understood that maybe it's some sort of cancer that's come into their lives. Now the big C is coronavirus.
Mm-hmm.
Uh-huh.
So hopefully it'll be long history, or at least will be solved to a great extent if we get in October this approval. We have Pfizer, we have AstraZeneca, Moderna. We have a number of companies that are pretty confident they're going to get FDA approval by the end of the month of October, which doesn't, of course, mean this will be available to everyone, to those of us who are distributed across the country by the end of the year, but it does mean that you see a solution on the horizon. So I think that'll change people's perspective a lot. But one thing I think that if we can find something positive during this entire period, it's that people have begun to acknowledge the fact that we're all going to die. It could be sooner than we think. It could be a lot sooner than we think, and that it's incumbent upon people to do the planning. But let's go back to the point that you raised. So if somebody doesn't have a will, talk a little bit about what happens in the state of Missouri with no will.
So essentially, when you pass away without an estate plan, you're forfeiting a lot of control over these assets that you've accumulated through your life. Missouri has these laws set in place to determine, what happens, how your assets should be distributed depending on your family situation. Like, do you have a spouse? Do you have kids? What are the different relationships you have within your family? And also, if you don't have an estate plan, the state can determine who will become the personal representative of your probate estate.
And you have no voice in it.
Right, exactly.
No voice.
Yeah, it's kind of based upon, I guess, a generic rule of thumb that the legislature, the state of Missouri, has thought is a good idea. What they would project on you as what you would have wanted if you had, in fact, created a will. And sometimes that's very much not what people want.
Right.
For example, to assume that because someone is currently in a status of married, and that's important, that status, not the quality of the relationship, and as a former divorce lawyer, I can tell you that those relationships can be really bad and still they're married. and it could be the person's last intention to give more than they have to the surviving spouse. But again, the law assumes this sort of June Cleaver. Soon I won't be able to use this analogy, but Teresa, I know you don't know who this is.
Yeah. I actually do. I actually know what you're referring
Ward
to.
Cleaver,
Yeah.
right? Beaver, and so that sort of family, they do exist. Of course they do, and sometimes what the legislature declares is going to happen is maybe what somebody wants, but there's a very good chance that it's not what you want.
Well, sure. Even with your kids, there may be children you don't want to leave anything to for whatever reason.
Yeah, and maybe you want to include a stepchild. Like, Teresa, under this, tell us, for example, how that distribution would be. And it would not include a stepchild, right?
No, it would not. So it looks by the law like blood is thicker than water, right? So they really value who are your biological, like, lineal descendants. So if you haven't... Well, I guess through adoption it'd be recognized as the same. But if you don't adopt, which a lot of people don't adopt their stepkids because it's just, this is the family like dynamic. They don't find the need to go through that whole formal process.
Or they can't, I mean, often you need the cooperation of the biological dad, for example, not stereotyping here. Sometimes it's the mom that is the one who doesn't have custody and yet won't cooperate with consenting, though there's no relationship. So in that case, if you don't do estate planning, then tell me what would happen if you have, so you have a couple kids and you have a spouse. Give us that scenario. How would the assets be distributed?
So actually, under Missouri law, if you are married and your kids are both you and your wife or both you and your husband's, then your wife gets $20,000 off the top of your estate, but then the remaining is split equally between your spouse and your kids, which some people find that could be okay. But actually, a lot of clients who come into our office, if they're married, a lot of times they say, okay, you know what? I want everything to go to my spouse first, and then after the two of us, then to our kids.
Now, what if you have kids, though, that are not of that spouse? Talk about how that affects.
So if you have kids that are not mutual, then your spouse would get half of your estate, and then your descendants will get the other half. So.
Yeah, those that are your kids but not hers.
Yes.
Yeah.
Exactly.
So I imagine this could create some major issues for the spouse, the surviving spouse, because if those assets are being divided up, say that the family home, could that home be taken away from that surviving spouse?
I mean, with the home, the personal rep or whoever the court appoints as the personal representative of the probate estate can say, okay, yeah, liquidate these assets and then divide it in half.
Yeah, I mean, the assets are going to have to be divided. The surviving spouse, especially if the kids don't like her, and this could be the classic scenario where you have kids from a prior relationship and they throw her out of the house. There's nothing that's going to keep her in the house if that money is needed for the division of assets, which presumably it would be.
Yeah. We'd also like to look at the deed, of course, to see how they actually own the house. But whatever is part of the decedent's estate would have to be divided
That's
equally.
A good point Teresa just raised. Explain what you were just saying, Teresa.
So if you own a home, these are kind of called what we call will substitutes. So it's kind of things that are considered before the probate process. So for example, if you and your spouse own your home, joint ownership with right of survivorship, that means if you guys are joint owners and then the surviving grantor or the surviving owner of the property would just be the sole owner of the property after one of them passes away.
So nobody could take that away then. Is that correct?
So yeah, that would just not be part of the probate estate. So that doesn't have to be divided at this point. So.
And doesn't probate take a very long time?
It could easily take up to a year or more than a year, at least 6 months. And that's in the most pristine,
most favorable
ideal
way.
Right.
Because, I mean, just notifying creditors, which we should probably take a step back in answering that so we give our listeners a little better feel for what probate is. The purpose of probate is very legitimate, and it's important that there be such a process, though probate gets bad-mouthed a lot, including by me, but many lawyers and people who've gone through it feel, gee, it was expensive, it was slow, it was complicated, and it didn't come out the way it should have, many might say. But so far, we haven't designed a better way except to do better estate planning. But if you submit to the process, which you don't have to, if you plan correctly, you can stay outside that process. But if you submit to it, then this is what it's trying to protect. On the one hand, it's trying to assure that the right people should get your stuff when you're gone. So that means that if there's a will, you can be sure you're going to probate. That's what wills do. So probate came into existence because courts, many over 1,000 years literally, have tried to figure out whether a piece of paper or this oral expression by the deceased was really what they intended. Is there fraud here? Because there's people who've passed away, of course, are the most vulnerable in our society, we can argue, because it's very ripe for fraud and misrepresentation.
I can see that.
So the probate process has to look at a thing that purports to be a will. It has to look at dates. It has to look at signatures. It has to consider allegations of fraud or undue influence, especially toward the end of someone's life. They're so vulnerable to that. People around them, exploiting their weakened mental state. So one purpose then is to assure that the people who a piece of paper says is to get it is in fact the right people. Another is, in the event that there is no piece of paper, to assure that, according to the statute we were just discussing, that the right people just get it. But then the second purpose, apart from assuring the right people, is to assure that creditors get paid first. I mean, ahead of those who are to inherit your stuff are the people who are owed money. And if any of us went out of the world at this second, I'm willing to bet that there are a number of creditors that we owe at this moment. And it would be a unsatisfactory economy where anyone who lent you money did so at the risk that you would die. And if you die, they forfeit their claim. That would be very disruptive to commerce, in addition to being unfair.
Right.
I have a question about notifying creditors. What if you have a situation where it's someone that has no children and they have a brother or a sister in another state that they're leaving everything to, and that sibling may not be aware of who those creditors are? How does that work then?
Well, the notification. Why don't you describe the notification process?
So after you open a probate estate, you have to send a notification to the beneficiaries, right? So if your brother, if there is a will, or even if they're just like whoever is your natural heir based on the statute that Missouri has, they have to be notified as the rightful owners of your estate. So in addition to that notification, yes, you also publish for creditors to come forward in that initial 6-month period. So after you open a probate estate, there's 6 months for the creditors to come forward and say, hey, I need to be paid. After that 6 months, a lot of creditors are then just out of luck. But you would do these things kind of concurrently, right? Notify the beneficiaries who can take, and then also notify the creditors.
Now, when you say publish, do you mean in a publication, a newspaper?
Yeah, there's certain...
an official periodical,
Yes.
something that's recognized, and often it is a newspaper simply.
Yeah.
Sometimes it's a legal publication, which, to be honest with you, isn't very good notice, but it still qualifies as notice.
Yeah.
But I think this is an important point, is when someone passes away, there is an obligation not to just notify the people in a will that might have been filed with the court, the people who are named there, not to just notify them, but also, the personal representative has the responsibility of notifying people that if that will were invalid, and if this were by what's called intestate succession, what we were describing a while ago where there's no will, who would take it, who are the natural recipients then? And that would be like a wife or children, et cetera. So they have to be notified. So when you think about, gee, why can't we just go down in an afternoon, have them look at this will, and say it looks valid to me, where do I sign, let the judge sign it and go down the road, is that there's the possibility that document's not valid. So who would argue against it? The only people that argue against it would be the people who would get something in the absence of that will. So all those people have to be contacted. Now, they can choose to sign a waiver in which they don't have to physically appear or participate. They're consenting to the court's decision. If it's a child, you have to find a guardian, or a guardian has to be appointed because the child can't sign as a 15-year-old. So suddenly you have this additional layer of authorization that has to happen. And then, of course, what about potential creditors? Well, anybody that, in fact, the personal representative has reason to know of or does know of, those specific entities have to be notified. But in addition to that is the publication we just talked about. So publication cannot be instead of it be as an alternative that you don't notify legitimate creditors that you know about. If it turns out that the personal representative have reason to know that there was this person, an individual in Tennessee, for example, that wouldn't have seen this publication but knew about this claim and went forward with it, then that would be a fraud on that person. So it would be a claim against the personal representative.
Okay, that makes sense.
But this all takes time. So when people say, I can't imagine why probate took, where there was no real contest, took a year. Well, that's how it can take a year. 6 months are gone off the top, as Teresa said a moment ago. I mean, 6 months, a clear 6 months for publications gone, period. And then you have court dates and other things to settle up. The person that's chosen as a personal representative is key. They're running the show with the court's oversight, but still it's an important appointment. You don't have any say over that if you decide to not have a will. You don't get to choose the person who's kind of stage managing and reporting to the court. So it is that for some people is the single biggest problem is that there's a dispute as to who should be in control, and there's actual litigation on the front end to determine who the appointment is.
And I know this would be rare, but what about the individual who dies and has no heirs, or at least to where, the state can't locate any heirs? What happens to, say, their house? Does the state take it?
So, yeah, it goes to the state if there's just really no one to be able to take. That's called escating to the state. And then the state has this, unclaimed funds where, later on they put it up and, some people can try to claim it. So.
And it's funny, and I won't resist the temptation to talk about the history of that because it's interesting to me, but probably only interesting to a small portion of you all. But those who follow such things, in England at one time, because you had a feudal system, things did revert ultimately to the king or to a lord at the top that had, you had a series of stratas in society. And so the idea of what's called, it's spelled E-S, like cheat, E-S, and then the word cheat, it's one word, S-cheat. And at one time, it made sense that if you died without this lawful person to pay homage to the Lord, that you had these duties, Lord, small L, that had these, you had these
Not
duties.
the good Lord.
Yeah, usually they weren't good.
Yeah.
But if they weren't going to pledge this fealty and to undertake these duties, like to fight for the Lord when required, et cetera, then those assets would return to the Lord above, and he could reassign them to someone else in that system. So what we have as a residue of that today, even in the United States, are some of these rules that have that origin. So yeah, if you die without a will and without an heir, and it only goes so remotely in your family tree, it doesn't go forever. And some states are different. Like in the Howard Hughes case, was that Nevada?
I don't remember. But.
Yeah, whatever state in which that battle took place, I think in Nevada, you could have it extend way down the family tree. So you would never have anything as cheat if you could find a 64th cousin, somebody who they call them laughing heirs, people who never knew you anything. They just get this.
I've not heard that. I love it.
But many states now realize, look, that's incredibly inefficient. It doesn't comport with what this person would have wanted.
Right.
And remember that's how this starts, is to come up with a plan that probably reflects what many people would want. Well, some people, rather than have somebody who's laughing to the bank, they'd just as soon it go to the state. So now in many states, I think Missouri's one of them. I don't know how far down the tree it goes.
In Missouri, it goes all the way until grandparents and their descendants.
See, and that's the trend. That's the trend, is to keep it close. And then if it fails, yes, and answer your question, Jill, it would go to the state of Missouri.
Mm-hmm. Wow. And you think that person may have wanted to leave their money, their home, to some sort of a charity or their church, their place of worship, and like you said,
or even a friend or something.
Yes,
if they
or
Yeah, you're right. They're almost certainly with somebody they would have preferred other than the state. So that's an example where, as to that particular residue from feudal times, it's not so much a representation of what the person would have wanted. It just, if all else fails, then it goes to the state.
If you're just tuning in, we are here with Teresa Yao from TuckerAllen. Now, Would you say that having a will is effective in, say, some situations where, say it is that person that doesn't have any family members and there's nobody that's going to contest it and they want to leave it to a friend? Would that be effective, would you say? Or could
Well,
you still have problems?
I would say in terms of whether a will is the right choice, it's not so much, oh, who do you want to leave it to? But it's more so, well, how, because a will doesn't let you avoid probate. If you're
Well,
trying
yeah.
to avoid probate entirely, then you need something other than a will. I would say in that situation, if you really want to make sure nothing has to go through probate and it goes to a friend, then like create a trust, right? And have the trust be the beneficiary, have the friend be the beneficiary.
Yeah.
But with a will is less expensive to do than a trust.
So
Am I correct?
your argument is that is it sometimes harmless, meaning that's not a whole lot of extra trouble to go to probate for
Right.
the reasons you mentioned.
Right.
You assume none of these sources of mischief are there, and that this will flow smoothly. And I could not get all exercise, nor do I think many estate planning attorneys could get emphatic about the necessity of a trust. But it just seems kind of pointless that it's true if you don't have many assets, then it is less expensive to have a will. So maybe if you're real sure there's going to be no conflict, okay. I mean, I wouldn't resist that. I do feel strongly that if you have any significant assets, and I'm not talking about rich people, I'm talking about anything above $300,000 or $200,000.
Sure.
I really think that it's unusual that it would make the best thing to do would be to not have a trust and just have a will. So just so people do get this, if you don't get anything else from this show, understand that when you have a will, you're not avoiding probate, you're using probate. And that's because probate's designed primarily for wills, though it will also cover cases where there's nothing, where there's no planning at all. But that's what probate was originally set up to do, is to deal with the will. That's not, as you're suggesting, it's not always a terrible idea. I don't like to come down on that side. But it just leaves a lot of opportunity for people to appear in the public notice, claimants for debts that aren't legitimate, and maybe there's no one there to defend it or to assure that there's not some fraud there. You often can't count on the personal representative, particularly when it's not somebody that is close to the family or there's some other person that you can trust. And then you have people who can still appear and make claims. It's much safer when you do one of the alternatives to probate, which we should talk about here, the most obvious of which is a trust. Let me try to explain this a little bit, and then you can take a run at it, Teresa. The way that something avoids probate is it technically is not in your name when you're dead. Maybe in your name at the moment that you passed out of this world, but it's not in your name when you're dead. So that sounds like, a pointless distinction, but here's what I mean. If you own real estate in joint names,
Okay.
like we were Teresa was alluding to this a while ago in this example, where a spouse, is she at the mercy of the kids, hostile stepkids for her.
Not the Leave It to Beaver family.
Yeah, and when Teresa said that she may not be at the mercy of them, she didn't explain that fully, but what she's referring to is that if you have a jointly held, the house often is as Sue and Jim Smith, husband and wife. So this is called tenancy by the entireties, or even as a joint tenancy, or the phrases. All it means is that whoever dies first, the other gets all of it. So that means when I say, is it in your name when you're dead, technically it's not in that case. The moment that your soul passes out of this world, so to speak, suddenly that real estate vests in the survivor in that moment. So there's nothing when you're dead as to that house to go into probate, because it's not in your name anymore.
It's not in your name anymore. Okay.
It was the joint and survivorship is another way that's sometimes said. So that sort of process I just described is true of bank accounts. It's true of securities accounts that you might set up where you have two names, or you name a person who is to get it upon death, payable on death, transfer on death. You commonly see this on stock certificates, et cetera. So what's technically happening, the reason that's avoiding probate is at the time you're dead, then it's no longer in your name. At that moment in time, it just instantly passed to the other person. So the judge in probate cannot deal with it. Now, having said all this, I will tell you that that's not a process that is impermeable for the court, because there are ways to get at frauds and other things. So there are occasions when a probate court will reach back and grab something that arguably they didn't have access to because there was some sort of fraud on the marital estate, for example. And a good example of this is if a guy is about to die and he takes assets that the wife would have had claim to in the estate, and this is under the model code is where it was borrowed from, right, Teresa?
The uniform probate?
Yeah. The model code wanted to protect often surviving wives. Statistically, guys die first. So some guys, if don't have a good relationship with their wife, they didn't divorce their wife, so they're married. And what they'll do is just briefly before their death, they'll secretly convey all these assets that they have in their name. They'll convey them to a trust of some sort. And knowing that the effect of that will be when they're dead, the wife will be able to claim those she can take against the will. So obviously, such a guy would not have provided anything for her in a will. She can say, well, I'm going to take half, for example. And if he didn't have surviving parents and children, she could claim the whole thing, right?
Right.
So it turns out that that the guy's kind of laughing in his grave because, she's getting nothing, right? He transferred it all just before death to a trust. Well, there are occasions such as that when a probate court has discretion in what's called equity to reach back and to grab that because it was a fraud on the marital estate. Yeah, this is often called like an augmented estate. And augmented just means that the court's allowed to consider transfers that were made. And this can cut both ways, incidentally. While it may not involve the court reaching back and grabbing something, the court, for example, in deciding that a wife, we'll use the same situation, surviving wife, and she's going to take against the will, and let's assume there's a lot of money, but let's assume also that she spent a lot of the marital estate just before the guy died, or maybe
that's what I was wondering.
Yeah,
what happens in that case?
Where she's the one, for example, that took the opportunity in some proximity to the guy's death to take a bunch of assets and use them in her own name or to spend them clearly for herself. So the point is, in that case, the definition of the augmented estate, when you include those assets that have been taken or used by one party or the other to the exclusion of the other, especially secret things, then that can work against the surviving spouse. So it's possible for an election to result in the surviving spouse getting nothing because by this definition of augmented estate, he or she already got it, or dissipated it in some way. So I do want that point to be clear to people that are listening is you can't do just anything with the assets just before you die and then have them immune to the court considering them if a wife's taking against the will, for example. So when we're talking then about changing the title on things just before death, that's kind of what led us into that discussion. One example, of course, is with deeds, and I mentioned transfers on death, payable on death. So that's a process in which you, if done properly, will avoid it being involved in probate. And of course, the most famous example of that, I think, or the most important, I should say, example of that, and usually the wisest, is to do that through a mechanism such as a trust, is to do that through the mechanism of a trust.
Because there's more protections?
Yeah. So, of course, you can say, I'll just set up my beneficiaries on all of these different assets and call it good because it's avoiding probate. Well, that doesn't really put you in the ideal position because if something were to happen to your beneficiaries or if you had wanted to make changes, then you'd have to go through each of your assets and make those changes. And so when you have a trust as the beneficiary, when you set up those payable on deaths, transfer on deaths, and the trust is the one named, then everything's just consolidated all together in this basket. So
and that's an important point, is it's a single basket. And in other words, rather than have a plan for every one of your assets, incidentally, if it's not done correctly, can actually transfer an ownership interest in the person in life, in which Suddenly, your real estate, for example, jointly held, if you choose to do that, as opposed to a beneficiary deed. I'm just throwing that out there quickly for listeners. A beneficiary deed is the better way to do that, especially if it's not husband and wife. But anyway, so many people, though, will think, gee, the way I'm going to fix this is I'm going to add kids or add relatives to the titles on bank accounts and on real estate. And that's often disastrous because suddenly that property has become vulnerable to all the problems in the lives of those people, whether it's divorce, bankruptcy, bad investments, simply reaching in and spending it. I mean, often that's a disaster. But even to do it through a POD, which I emphasize to our listeners, remember, these do not give current ownership. It is an absolute train wreck. It's a terrible mistake for you to add people to titles of documents versus a POD, payable on a death, a TOD, transfer on death, a beneficiary deed I just described. All those things don't give them current, immediate ownership interest. So there's no tax consequences, divorce, bankruptcy, those things I was mentioned. At least those do not trigger a problem when they develop in the lives of those people who are named in those documents. That's different from naming them as a co-owner, which is what all too many people do. Teresa, how many times have...
A lot of people come in, and every time I go through the asset list, I'm like, do you own it jointly or separately? And they're like, jointly. But a lot of times it's not with the spouse, it's just jointly with their kids. And what that means is it's opening up the net of creditors and liability that this asset originally had, to more. So
because if that adult child is involved in a lawsuit, then that parent could be
those
brought
assets
in.
are
Those
joint,
assets, they're joint, right? Like a home,
That's
something
right.
like that.
Exactly.
So a parent, the other owner, in this case a parent will say, is suddenly drawn into this lawsuit because they're trying to protect this property. And this property is really what's being pulled in. And so it means that the homeowner is probably going to incur legal costs trying to protect this property from a creditor that wasn't even theirs, but of a co-owner. So in any case, if somebody walks away from this with a short list of things to remember from the show, one of the items on that list has got to be, do not put people on as co-owners on accounts of any sort, including real estate. But Teresa, you're going a step further than that. You're saying we don't even recommend that you do it with a payable on death or a beneficiary clause. There's a better way to do it, and that's what leads to the discussion.
To the trust, right.
Exactly. And unless you have one or two bank accounts or just a very minimal variety portfolio of assets, then maybe setting up beneficiary designations directly to individuals might be okay. It's just that most people have slightly more than that. And
right.
You don't want to have to update. And it takes a while to do that homework. I like to tell the clients, this is homework that you have to do to create those beneficiary changes with all of these different institutions. Whereas if you have the trust as the beneficiary, all you have to do is update the trust.
Yeah, and everything is operating under the same set of rules. It just makes so much sense, and it gives you much better opportunities for planning because once you've created the trust, you have this vehicle, it doesn't cost you any more to say, gee, I think I'll go ahead and have this paid out over 5 years, and that can be beneficial to the beneficiaries. And depending on their ages, and incidentally, I would argue that even if your child is 30 years old, I would not jump to the conclusion that if you have $200,000, for example, that would go to that child, that you should hand it to them. I mean, I'm a big believer in this. Yeah. It's not an insult to your child. As a matter of fact, it protects your child in terms of asset protection. And if your child knew as much as a good estate planning lawyer knows about this subject, the child would be asking for it. The child would be saying, wait, don't give me the $200,000 because that's going to be immediately vulnerable, number one, to my divorce. If it ever happens, we don't want our children to get divorced. I get that. But look, we all know it can happen. And whenever you place money in your children's hands, I'm telling you, 1 in 20 clients have I seen who've known how to properly, immediately assure it doesn't go even for a moment into the wrong account, that the earnings from that are carefully sequestered from all their paychecks. Even the paycheck of your child cannot be mixed with that money without making it a marital asset, or at least having it commingled, potentially inseparably. So the whole idea here is to give your child a gift of protection, not just from divorce, bankruptcy, we mentioned that, creditor problems, all sorts of ways in which something you intended to have a dramatically good effect on your child's life instead becomes a source of worry and disappointment.
Well, and two, you might have that child, even if that child is 30 years old, who is financially irresponsible and would blow through all that money within a year. And you want to protect that child from something like that.
Now, that particular can of worms is one of the most common problems. But I've found that parents often don't know their children as well as you think they should. Well, they want to think the best, right?
Well, yeah.
And so sometimes that child that hasn't demonstrated the ability to manage money well, they still think, well, maybe he or she'll do better. Then you have those people who, and I see this a lot, Teresa, how often have we seen somebody who comes in and says, look, I'm not going to try to rule from the grave. That phrase drives me nuts. I'm not going to rule from the grave, I'm going to let my child do what they want to do.
Definitely familiar sounding.
It does, but here's the point. If you're alive, you would know to not do things that harm your child because of your child's bad habits or bad predispositions or whatnot. Even when your child grows up, to not do things that the child will not handle correctly. So I would argue that policy that you started when the child was 1 year old, why change that policy?
Right.
Just because they're 30 or 40 or 50, if you know that child is going to drink through that, is going to make a lot of bad investment decisions that's going to cause them worry and frustration, maybe depression, why just be indifferent to that and say, well, they're over 21 and it's their problem now? I think most people still want to try to give gifts wisely.
Yeah, and provide them with that guidance. If you're just tuning in, we are here with Teresa Yao from TuckerAllen. And Teresa, it's always a good idea to review your estate plan every 3 years, correct?
Yeah, I would say at least every 3 years, and then more often if you have significant life events that happen.
And what would that be?
Like if you
what does
get
that
married,
look like?
or if you have kids, if you get
divorced.
divorced.
Get divorced, yeah.
Hey, mention that quickly about the rule. Some people think that if you get divorced and you don't rush in to do the corrections, which we still argue you should go see your lawyer after a divorce. It's one of those major events.
Yeah.
But we can give people some peace of mind by telling them that the statute is not what many assume it is when you get divorced.
Yeah, when you get divorced, essentially the spouse is considered to have predeceased you. So they don't really have that connection with you anymore.
Yeah, almost all 50 states now have made that change because it was disastrous, meaning people would get divorced. And I know this from Cordell and Cordell. The last thing they want to do is hire a lawyer after they've gone through an expensive divorce, is to hire a lawyer and deal with estate planning. I mean, they're out of money typically because divorce, you use up a lot of your liquid cash.
Right.
So you end up without a lot of cash sitting in bank accounts. Yeah, I mean, it's in real estate, it's in retirement funds and whatnot. So often these people don't do estate planning. So thankfully, many legislatures across the country have a similar statute that says that if you don't get in to make that change immediately, then at least it won't result in that person getting half your assets the way we were just describing. But back to Teresa's point, is that an example of a major change in your life where you should amend your estate planning? Of course.
Yeah, ideally, yes. You would just change the language, have it be as clear to your trustee, your personal rep as possible. Because after you're gone, they can't consult you about what you wanted. And then so just, I would say, review it every 3 years. Anytime a significant life event happens, update it, review it. And
on this topic that I want to mention is something that TuckerAllen does. And you should ask your lawyer, if you have a estate planning lawyer, if it's not, for example, TuckerAllen, you should ask for an arrangement in which you can come back regularly to have them review it, either without charge or according to a monthly plan or something, or annual plan. And what I'm referring to, and this is increasingly common, TuckerAllen's been doing this for some time, is that you can come in, you can have estate planning done, and part of the fee is an option in which you pay an annual amount. It could be, I don't know the numbers, it could be $200 or $300 or $400, in some cases $500, depending on your estate. But it's a certain amount you pay per year or per month, and what that gives you is the right to go in regularly, more frequently. In other words, the whole idea is to encourage people to come in and do estate planning. So, for example, if you could pay $500 a year and get the right to have an unlimited amount of contacts regarding changes in your life or questions on your estate planning, not only would it save you a lot of money when you think about it, the hourly rate of a lawyer, but it lifts the burden from you about, oh, I hate to call my lawyer and ask him about this. Instead, you think, oh, I'm paying for this. I think I'm going to call my lawyer and ask him about this. So we found that it's the best way to assure that people will come in and do the thing that Teresa was talking about, is to regularly follow up if there's a change.
It's a good reminder.
Yeah.
Every year.
So.
And it's part of your agreement.
It's the expectation in the relationship. In other words, hiring an estate planning lawyer, let me tell you, those of you especially over 60, is you should assume this is going to be a relationship for the balance of your life. This is not a single transaction. If you have an estate planning lawyer who views this as a single transaction, you ought to question whether this is the person who should be your lawyer.
Right.
You should be establishing a relationship that will change over time. It doesn't mean, though, that the initial plan you had is real vulnerable and that, oh my gosh, I spent $2,000 on trust planning, for example, and it's going to all be worthless because of changes in my life in another 2 or 3 years. No, if it's designed correctly, it will require minor modifications over time. There probably never will be a time when that plan will fundamentally change because you're in doing your planning, you want to think about things that are important to you and consider the possible changes ahead.
Teresa, does this happen very often when people are reviewing their estate plan where they want to add an heir or even remove an heir?
All the time. People come in for changes all the time. And that's why I think this maintenance plan or this maintenance kind of mindset is really, really important, because in TuckerAllen, we have this maintenance plan where if you join it, we review your document every year and you can contact your attorney unlimited amount of times. And it also includes, a lot of time people just want to come in to change the name of a beneficiary or to just change a number in there for a distribution amount. And those are minor changes, pretty simple to change, but outside of the maintenance plan for us, that costs $350 just for that change. But if you're under this maintenance plan, I think it's $300 a year. You can make unlimited tweaks into your estate plan.
Well worth it.
Yeah, and the whole idea is to encourage people to come back and make the updates that they need over time. And as Teresa's saying, often they're very minor, but occasionally there could be a fundamental change where something came out of left field that neither the lawyer nor the client could possibly have imagined. But normally when you have good estate planning, it's always around the edges that you do the updates. Rarely is it to the fundamental plan.
What about the folks that want to do, say, an online estate plan? That can be a disaster.
Yeah, that's
an online will.
Normally a disaster, I would say, just because they're so template, it's just formed around a template. You can't
One size fits all.
Yeah, and you really can't go into the document and customize that language to fit. If you have any deviation from kind of the default, it's really hard to incorporate that. And also, if your family situation's just slightly different from the Cleaver family, you'd want to consult with an attorney to talk about, okay, well, what's the best way to set things up in your whichever estate plan that you pick. So the online form really takes a lot of that conversation and consideration out before you create this plan.
Yeah, and it takes the education out. One of the primary responsibilities that your estate planning lawyer has, your elder lawyer, is to educate you. And if you have somebody who's speaking in a bunch of multi-syllable words and you don't understand what they said and they simply impose on you essentially a plan where they say, oh, this is what you need, then you should fire that person. Because among the most important roles that your attorney will play is to teach you what all these options mean. I'm pretty confident that's not going to occur online.
No.
And I'm pretty confident it's not going to occur in a form, even with instructions.
Yeah.
Well, we're out of time. Boy, time flies.
Yes, it does.
I think, though, we talked about a lot of important things. I hope you found it interesting and helpful. We'll return to these topics from time to time in the future. This has been another episode of Elder Talk. Till next time, take care.
You've been listening to Elder Talk with TuckerAllen, providing intelligent answers for those thinking about their future, with Attorney-CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of Elder Talk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.